Tell us a little bit about Julie, because I know you want to tell us how we can find you and get in touch with you if we need your help, and then we'll go on with our questions.
Sure. My name is Julie Anderson. I'm the managing member of Anderson and Associates. Our website is www.mo for Missouri, KS for Kansas, LAW for the law.com. We have a lot of resources, all free to landlords for both Missouri and Kansas. I really encourage people, whether or not they hire us or not, to use our forms. They're state specific. I think one of the biggest problems that we see in this side is that people just find things on the internet. So if you're going to find something on the internet, I just gave you the web address for the state of Missouri and Kansas when it comes to tenants. We put it out there for free because I'm just tired of trying bad cases with bad notices. So we're doing eviction work, foreclosure work, some repossession work. We have a transactional department, a bankruptcy department. I often say I'm just in the business of keeping real estate investors in business. And so that's why we're here, talking about what's going on right now.
So this is some of the free forms Julie has on her website. So if you're looking for a form, I would definitely check it out. You might find the one you're looking for right there on her website. And she probably won't tell you this in her presentation, but if you want a complete set of forms that have been in front of the judges here in Kansas City, she sells a lovely contract package for the state of Kansas, and she sells a lovely package for the state of Missouri, and you can reach out to her office and they can get you set up. So I just wanted to share that. The first question I have been hearing is all of the rental assistance money gone, or is there still some out there to be had?
So the emergency rental assistance program that was coming through the federal government is very close to over. I would say as a landlord, you should consider this to be done as of right this minute. If your application is not already pending, the federal programs, including SAFER, no one is accepting new applications. CSL, so the Community Services League, right now is the only organization accepting new applications. Those have to be applied for at the courthouse. And that's the only way in which a tenant will get assistance as of this moment. On the 4th floor of Jackson County downtown, and then they're also doing in Independence, another remote location for CSL, and I'm not exactly sure. They keep moving them from place to place, so I can't tell you exactly where to go. But at this moment, that is the only rent relief that's available. There is discussion that Congress will push forward additional rent relief. CSL is only providing assistance for people that have not received 18 or more months of assistance, and they meet the 80% of the area medium income bracket test. I think that as a landlord, what I could communicate to people is that there is not rent relief right now. Just, you should not let people get so delinquent that you're waiting.
I know way back when I had some rental properties, if our renters got behind on rent, like the community, the Catholic Charities or the Jewish Services, they had rental assistance. Do they no longer have that, or outside of federal programs?
Yeah, we are seeing numerous resources, shelters, schools. The United Way right now is not taking any new applications, but they're hoping to get another grant. Private community organizations are paying rent. I would not sit there and wait and hope, because you're going to wait quite a while, and then in the end you could find out that they're not going to fund.
And even if they did, they're usually only doing a month, not 18 months.
Right. I think right now the best advice I'm giving people is that you need to have a policy and a procedure regarding evictions. You know, if you're investing in real estate for a living, If this is your business, I mean, if this is your hobby, then I guess you can do whatever you want. But if you're doing this for rental returns or income returns, you need to have a process and a procedure. Also, if you have multiple units, we are seeing a number of increased discrimination claims from evictions. So you need to have a policy and a procedure that says when a tenant is this far behind, I'm going to send it to eviction, or I'm going to send this delinquent notice and then this process and then to eviction, regardless of, you know, race, religion, sexuality.
Yeah, you have to treat every tenant going out the same as you do have to treat every tenant applying to rent, correct?
Correct. It's the entire experience. So, and I understand, you know, a lot of landlords, especially smaller landlords, you feel bad. You feel bad sending kids and moms out on the street. But really what happens to you is that you get sued because someone who might be in a minority status, you know, spits in your face and screams at you, but they have to be treated equally. Like, the world will not view how you feel about one tenant versus another, or how you feel about their situation. You must treat everybody the same. And the best way you can do that is to have written policies and procedures regarding how you handle tenants coming in, how you screen them, how you lease to them, how you deal with them during the lease, and then how you evict them. You cannot let some people behave poorly, but not others. You cannot let some people not pay you because you feel bad while you evict others. So if you just want to run like a fledgling business and not require anybody to pay you, you're welcome to do that. But that's called a hobby, not a business. And so I can't encourage people enough to start like tonight. Just say, if they're not paid by the 15th, this is the notice. This is when it goes.
Okay. And I'm going to say, especially in Kansas City, Missouri, now that they are offering, or not offering, they are providing free attorneys for the renters, that might be one thing that the attorney might look at, that, hey, you didn't evict this renter over here until this far down the road, and now you're here, so you're treating them differently, so now you can't evict anybody. That might be an argument they might have in court, I would think.
Yeah. I mean, there's a lot of arguments. I kind of call it the flavor of the week. You know, landlords are under attack, particularly in Jackson County. Kansas is running pretty smooth. I'm really pleased with what we're seeing at post-COVID in Kansas. But if you own property in Missouri, and there's many reasons why you would, particularly in Jackson County, it's just a lot. There are a lot of challenges.
So the free attorneys are being provided for anyone in eviction court in Kansas City, Missouri. Is that, I know they were getting rental assistance, but now as the rental assistance winds down, I know it's adding time, but how much time is that adding? And how much cost is that adding to an eviction if they end up fighting it?
You know, I can say on the rent and possession side, when we have cases where we're filing and they're just, 15 days behind when we're filing. So they're only 1 month behind when they're getting served, maybe 2 months by the time we're in court. It's easy for these free attorneys to find a source to pay 1 or 2 months. But if you are waiting 18, 20, 22 months, like, you're not going to get paid. It's just, it's very difficult for them to find any resources at this time and ongoing. I also feel like filing early and often, according to your own policies, of course, not just because you woke up and decided to do it without a written policy, but I think it does train people to say, like, you are this is a business. I think with smaller landlords, you don't have an office necessarily. You don't have, you're not a big multifamily housing complex with a sign over your doors. But that doesn't mean you're not running that business, and you need to mean business. So when you lease to somebody, you have to say, rent is due on this day. It's late on this day. I will give you this notice on this date, and then you will be evicted. I think it trains tenants very early to say, I have to make this a priority. Because honestly, over the last 2 years, it has not been a priority. Our federal government has said it's not a priority. Or we'll pay it for you. And now we're seeing, people, a lot of applicants that got 18 or more months of free rent back in eviction. And proceed with caution. Be really, really clear what you expect. And then you have to treat everybody the same, no matter whether or not they have children, or you feel sad, or they go to your church, or whatever it is. You cannot treat them differently than other people, because those are the big checks that my clients are writing right now, because they felt bad for somebody and they treated them differently.
And then fair housing can get involved, and that can be hundreds
it's
of
expensive
thousands of
and
dollars.
You don't want it. You just don't want it.
Okay. So if you're a newer investor and you're doing all of your management yourself, written policy and procedure is a must for every aspect of the rental, moving them in, selecting them, managing them day to day. If one renter wants,
if that's not your policy when you buy the property, then that's not what you're going to do.
Right
now, I don't want landlords that go out to the property and pick up rent and cash and things that we can't claim.
Right.
It's really messy. There's so many amazing online portals now where tenants have to have legitimate funds that they can pay you online. Almost everybody has a phone or access to a computer, or you could provide some limited number of hours where they could come to a computer in order to pay. I'm not doing a lot of payment gain cases right now. I've had a good number of fraudulent payment cases over time, but that's not really a hot ticket.
But you want to accept your payments. You want to provide every tenant the same opportunity to pay across the board.
Yeah.
Not that you're going to go pick up Susie's rent from her in cash, and then everybody else has to go to the online portal and pay online. All right. So what's my next question? Should we have any new protocols, given the fact that we have, at least in Jackson County, have new protocols like, okay, I'm going to serve notice on this day, but I'm also going to offer cash for keys and pay them to leave. I've had a few people asking about paying the renters to leave.
When people ask me all the time, should I pay people to leave? I'm going to offer to pay them to leave. It's easier and it takes less time. Okay, well, you're feeding, in my opinion, when you pay someone not to pay you, you're feeding the problem. And some of them might take it, and so that's great for you. But also some of them won't, and they're going to be like, aha, what's wrong with you? And then we're in for a far more contested case than we would have ever had in the beginning.
Okay.
There are times, I advise some of my clients, I have in the past, especially when they buy, foreclosed properties in the past, go and meet them and offer them $500 moving expenses. That'll save you the money. You got to flip this property. You need, we're going to have to pay for an unlawful detainer. We're going to have to issue a 10-day business notice. Oh, if that makes sense from your business model, do it. But you have to do it every time, regardless of their race, religion, color, sexual orientation, familial status.
Well, if you're going to offer cash for keys to one tenant, you have to offer it in the same amount to every tenant.
Right. And why are you paying people who don't pay you? Why don't you just teach them up front, you have to pay me? I sound like I'm teaching kindergarten, but with a martini. I'm like, there is a consequence. This is kind of consequential learning.
Yes, but you have to, I agree, in everything you have to train people. I mean, when COVID hit, I had to train everybody how to join us on Zoom.
Right.
This was my question. So all of the experts out there are harping that we have so many evictions filed every month in Kansas City, Missouri, or in Jackson County, or any other city. They're all harping on it. But out of an average number of evictions that get filed, I know a lot of them are not even occupied, not a lot, but some of them might be unoccupied properties, or some of them might be foreclosure properties that you acquired. So do you have a gut feel? I know you don't have exact numbers, but are percentages of evictions that have no tenants, or the tenants have already left and you're evicting the stuff just to get the property back, something like that? I mean,
both states, both Kansas and Missouri, have an abandonment statute that's pretty specific. So I don't feel like we would need to. There are some times when I might advise that we get a court order for extra protection. Somebody dies, a caretaker has access, we don't exactly know who's coming and going, they may or may not be there. I don't think we're going to qualify for abandonment. Then yes, I'd like to have a protective order from the court just to make sure that you're not stealing. It's so much better if you have to put estate property out on the curb with protection versus like figuring out, are you going to be sued in the next 5 years because you took all these heirs' property? That would be an example where I'd say like, yeah, we're going to go ahead and file and get a protective order. But I mean, abandonment is cheap and easy. Literally, you can get on my website and read step by step how to do it if somebody's not there. I feel like right now we've just come out of 3 years of our federal government saying you don't have to pay rent. Paying rent is not a priority. Your life, your ability to sleep in a safe space paid by somebody, the private investor, is not a priority. And then we had rent relief, where we're going to pay it all. We'll just give you free money, whether you deserve it or not. You get a free lawyer. Still to this date in Jackson County, you get a free lawyer, even if you make $250,000 a year. And I mean, that's obviously a rare experience, but it has happened. That's where we are politically with evictions. I still think that people can run smart investment businesses and still make good returns. You only have a few choices where to put your money. You're going to put it in the real estate market, you're going to put it in the stock market, or you're going to invest in, I don't know, cybersecurities or metals.
crypto.
Crypto, metals, stock market, or real estate. And I think real estate has shown great returns. It's just more litigious than it has been before. I come to you, post COVID, saying like, you're far more likely, things are difficult. You're far more likely to get sued. You cannot just do handshake deals anymore. It's over. You just can't let people just pay you on the willy-nilly and gut it out. Like my gut experiences. Oh, I liked her, or I liked him, but I didn't like her. Can't do that anymore. You actually have to have, if you call it an investment, it has to be a business. And that business needs processes and procedures that are in writing. So when or if you get sued, I can tell somebody based on the number of units, I'm like, well, it's not if, it's when.
So
You'll get sued.
Having a professional property manager is probably the right professional property manager would be a right move for somebody, just to make sure that all of their renters get treated the same, and that there are policies and procedures if you don't have your own.
Yeah. I mean, I think a lot of people right now are trying to, I think they're trying to be kind of cheap about their property managers. They're not hiring professional property management companies. They're like, oh, I found this girl on a Zoom call.
Yeah.
She's my property manager.
My friend.
She's my friend, my sister, my sister-in-law, my sister-in-law's cousin.
the contractor that rehabbed the house is my property manager. There's a lot of those type of property managers that I run into, and they're just somebody that'll go collect the rent. Because you need to drive to a house and have somebody give you cash in your hand. I don't know why people do that.
Well, I don't have a problem with that. My issue is that they're not doing it in any way that I can prove on the books, following a process and procedure that's in writing.
And
And
then who's to say that that person collecting rent for you in cash doesn't like go to the boats and blow it all and then say the tenant never paid the rent.
don't worry, that's already happened.
I know, it happened to me.
I was like, oh no, that happens. Yeah.
So
don't
I
do
know a
that.
lot of people have questions. I don't want to get too deep into the weeds on this tenant did this and how do I deal with that, because that's too specific of a question. But in general
Maybe.
questions, I would love to have some questions. I know we have a few, but we had one question. Brian Winberry had a question. I know at one point when a bank or us as a lender would foreclose on a property, and there was a renter involved, we weren't foreclosing the renter, we were foreclosing the person that owned the property. So if there's a renter in that foreclosed property, do we, whoever forecloses have to still honor that lease? I think there was a law put in place back in the last Great Recession, and we didn't know if it was still in effect.
It
Or,
is.
so we have to honor the leases.
It is still in effect. I will say we're rarely, the national lenders are not foreclosing yet. I think next quarter is going to be a really big jump. It'll be late in the quarter, maybe third quarter. I anticipate a significant number of national lenders foreclosing. When they took federally funded bailout money, just like everybody in the country, there was a procedure through the CARES Act where they couldn't foreclose, and they have not yet started foreclosing. There's a big issue whether or not the CARES Act is still in place or not in place, and which provision applies and which does not. So I do anticipate that the lenders will start foreclosing. If you're a private lender, lending money, and you foreclose, you still have to honor a lease.
And when you sell, you have to honor a lease. I see so many people, they're like, well, I just bought this property and I changed the rent and I changed this and I changed that. I'm like, and the tenant's not happy. I'm like, well, did the tenant have a lease? You had to honor that lease. You can't just go change everything because there's a new owner. You can change maybe some of it, but not across the board, everything in the lease.
No, you can't. I mean, you cannot change the term of the lease if it's a legitimate lease. Now, if it's on a month-to-month, you can give them 1 month's notice or 1 term notice. One thing I want to be really clear about with landlords right now is 1 month does not mean March 8th to April 8th. It means February 28th at 11:59 p.m. through March 31st at 11:59 p.m. So when you're getting these 1 month notices, do not think giving it on the 1st or on the 3rd or on the 8th is a legitimate notice. And that's a really punitive result for people that are trying to do a lot of things on their own. But yeah, you have to honor the lease. Protecting foreclosures or protecting tenants at Foreclosure Act is still in place. I will say I haven't heard that word in a long time. Now, possibly it's because of COVID, but it's been a good 3 or 4 years since we've had anybody raise that issue.
Well,
I'm not
I
saying,
believe,
but it's going to come back. I mean, with the current federal government environment, they're going to, if not just declare it reinstated, which they wouldn't have to, it never expired, but make it even bigger.
the reason why we're asking this, and I think Brian was asking I'm honoring leases when you're foreclosing. He's looking at that same backlog of foreclosures that the banks aren't foreclosing. And in the note world, a lot of those banks sell those to hedge funds who end up selling them to people like Brian and myself, who then foreclose. And he's like, okay, I'm the bank now. So what are my rules and regulations? I just wanted to, he wanted to get an update if that had changed.
It hasn't. I mean, the note sales world is the same that it always has been. You're gonna have to go through the steps to foreclose. And then afterwards, in Missouri, we'll have to evict. In Kansas, we can do it all in one,
Okay.
all in one case.
Unless there's a tenant, and then the tenant has to be honored.
Yeah, in some ways it's easier if there's a tenant in Kansas, but the process in Kansas costs like 3 or 4 times as much and takes 4 times as long. So I'm kind of like, I don't know, it's tit for tat when it comes to these foreclosures.
One question, and we're going back to paying cash for keys, asking, we have to offer the exact same cash for keys to every renter, every tenant that we have. Why is that?
I don't know. I mean, there's not specifically case law that says cash for keys, you have to use equality. But I can tell you, like, why would you give a white man cash for keys, but not a black man? Why would you give a Christian cash for keys, but not a Muslim? Why would you give a married couple cash for keys, but not a homosexual couple? So it's not that you have to offer the same amount of cash for keys. That's not really what the law says. But if you get sued or a complaint is filed against you by someone in a protected class, I need to be able to explain, why is it that you chose to make a different decision for one person, couple, race, religion than another? I mean, I don't know. I mean, maybe there's a reason. Maybe it's because the property was this and it wasn't worth it. And no, it's over. COVID ended friendly and fair, you know, friendly and case specific. It's just, in my opinion, and of course, I'm a semi-jaded person, but you just can't do it anymore. You can't take people and treat them differently based on how you feel, because how you feel, you know, in the eyes of the law is based on your own biases. You know, people that are in your community, people that know your family and friends, people that you have some relationship to, whether it be your church or your community, you give them more leniency than someone else. You give them more cash and key for keys. You pay them. Now, when it comes to rent and possessions, I'm just like, why would you pay someone who doesn't pay you? Like, that's ridiculous to me. But of course, I'm not running your business. I'm an attorney. I don't run your business. I only have to run my own. You can't do it anymore. It's over. You have to now have, even as a small business owner, you must have policies and procedures and follow them. And you heard it here. And maybe you'll get caught, or if you decide to disregard it, maybe you'll get caught and maybe you won't. You know, maybe you'll go another 20, 30 years and have no problems, or maybe you'll have some big problems.
Matthew on Facebook has a question. He's on the Kansas side and he's asking, can you talk about tenants in Kansas that withhold rent while waiting for repairs to be completed that aren't habitability related? Things like they would like a new screen door when there wasn't one, or when they moved in, you know, there wasn't one when they moved in, so they're withholding portions of the rent until that minor thing gets fixed. Are they allowed to do that, or how should they handle that?
So in Kansas, there's a 1430 notice that's required by both the tenant and the landlord. So the tenant must serve you a 1430 notice in order to withhold rent, saying, I'm giving you 14 days to repair my screen door because it's an issue of habitability. And if you don't, then I'm terminating on my 30th day and I'm moving out. And if they don't give you the notice and they don't move out on the 30th day, then you should issue a 3-day notice and evict them. And the nice thing about Kansas is that we can bifurcate all these issues and just get possession. So the sooner that you just call it, if your tenants are not doing the things that they should be, which means paying you and taking care of your property and issuing appropriate notices, then you just call it. and say, no, I'm issuing a 3-day and we're gonna go to court. And the judge will say, did you issue a 1430 to the tenant? Because they have to issue that notice. They have to give you 2 weeks to repair whatever they consider to be an issue. And if they are just texting you or calling you or putting on a portal, that's not a valid notice.
They need to give you notice that they're gonna withhold rent on a specific form and
Yeah.
why.
Yeah, I mean, the Kansas Residential Landlord Tenant Act is pretty clear as to what tenants have to do and what landlords have to do. That being said, I really highly encourage you, Kansas landlords, to also read my frequently asked questions for Kansas landlords on the website, because, you know, I think today I've had 2 conversations with landlords in Kansas where I'm like, after you issue a 3-day notice, if they pay you, you have to send a reservation of rights letter. And I don't know how to get the word out more than just right now. You have to do it. If you don't do it, your case will be dismissed.
Okay, so he's well, on those tenants, he was asking, okay, so his tenants were just texting him, they wanted the screen door repaired, they gave no notice, just withheld the portion of their rent for the month. And does it make any difference if they're on Section 8?
No,
Section 8 usually doesn't withhold rent unless,
no. Section 8 is not going to withhold rent for a screen door. Now, if there was absolutely no door, then you could lose Section 8 certification. But that's not what this case is.
okay, so what if we have a tenant that is a criminal and dealing drugs out of your unit or doing other high crime things? Is there anything to speed up evicting those tenants? We have a person in the chat. She inherited her renters passed away with COVID, and her children moved in and were causing all kinds of havoc. Not her children, the tenants' children moved in, and they were drug dealers and just horrible people committing crimes, and she couldn't get them out. She did not work with you, but she was struggling getting them out. Is there anything that they need to do with lawbreakers?
Yeah. I mean, I'm assuming this is Missouri.
And the police wouldn't help her. The police would not would not do anything to enforce anything. They wouldn't knock on the door or anything.
The police are not going to help landlords. And that's the world we're in. Those are criminal issues. These are civil issues. When somebody moves into your property, they acquire a possessory interest. Like, you have legal title, but they have a possessory interest in your real estate, which is how they acquire their rights. That's kind of the history of the law. And so that's why the courts protect them so much, because they have this interest in your real estate. Now, if you have a police report, which I don't care, I mean, you could walk one in and give me one, and you have actual evidence of these things. Here's the problem with emergency evictions. People will call me and they'll say, they're doing drugs over there. Okay, have you seen the drugs? No, you haven't seen the drugs. Okay, well, how do you know there's drugs? Well, somebody told me. Well, who are they? Will they testify? Oh, no, they won't testify. Okay, well, now there's no drugs. Like, I need real evidence, pictures, eyewitness experiences, documents, photographs, police reports, in order to prove emergency situations. Now, you know, an emergency eviction is not an emergency, but I mean, we can take right now about 4 or 5 weeks off the process. And if you need it, we're filing them. I mean, I file at least 2 a week. I prefer, if it's not truly an emergency, like maybe it's an emergency or it's questionably an emergency, that we also issue a 10-day in Missouri, so that we're backing up with an unlawful detainer if I don't think I can make the case as an emergency. But I will often file them and then amend, you know, 10, 15 days later, if I think we can't make it. But we should be able to make them. And that is, It's not an emergency unless you have evidence. And evidence is not what someone else told you, it's what you know.
I would highly recommend, if you're have never been to Julia's Crime Free KC. Is that the website, crimefreekc.com?
Yeah.
I would check that website out and take the free 8-hour class. They talk a lot about how to keep crime out of your property, things you can do to, just deter people from breaking in and things like that. But they also teach you how to use your leases. They have a lease and an eviction sent part of it so that you can make sure you know how to get the crime out. And they also certify you so that you know what drugs might look like, what they might smell like. At least they did last time I went to the class.
Yeah.
And it is also taught partially by attorneys and partially by the police department. So getting in good with the police department would be very helpful in knowing certain officers' names might help you out at the police department too. So I would definitely recommend that.
I definitely recommend it as well. You want to be there voluntarily, not involuntarily. My involuntary landlord class is not very fun.
I thought I've been to it 2 or 3 times. I've brought lunch a couple of times and it's been fun every time. We're just not doing it as many times a year as we used to.
Yeah.
This COVID. So raising rent. So everybody, I think we've all raised our rent and now we're lowering rents. But if we acquire a property or have our own property, how much can we raise rent? Are there any limits on that in Kansas and Missouri?
No, there are no limits. I mean, I think people are talking about it. It's big news. It's a lot of lip service, but it's a free market right now.
You can't do it in the middle of the lease, but if you're on a month to month, you can change the right. Raise the rent.
I mean, you cannot raise the rent if you're in the middle of a lease. And landlords sometimes are confused, not often, but sometimes they're like, what? I have to follow my own documents? Yes, it's a contract from both sides. We all have to follow it. So if you give somebody a 1-year, lease for a certain amount, you cannot just change it unless you have some sort of provision that says after X number of days, I can change it. The market is fluctuating, and I will definitely say things are far more difficult and expensive now. Inflation is an issue. Evictions are more difficult, especially the longer you wait. Very few of my clients have highly contested evictions when they file in the first month or the second month, when people are delinquent. Those are not my contested cases. And we have a long list of contested things that have to do with people that waited a year. Like those, after you let somebody live for free for a year, they don't want to leave. If you let somebody live for free for 15 days and then you bop them on the nose, like the case is a lot easier. I mean, not that I'm here to try and make my life a lot easier, but it's a lot easier when you tell people up front, here's what I expect. Here is the consequence. This is what happened. Now here's the consequence.
So one other thing, as we're being able to, the tenants are able to have a request to trial, not just normal eviction with the judge. Are there any clauses they should have in their leases about that?
It's the landlord's burden to prove by a preponderance of the evidence. That's the standard that we have to do in civil court. That means it's more likely than not. We don't have to do beyond a reasonable belief, which is what you hear in all the criminal TV shows. But I mean, we have to prove our case. And that means you need to have a lease, I hope a good one. And you need to have a ledger that's comprehensive. And you need to be able to prove, if we say they're dealing drugs, we need to be able to prove. And I would say a lot of landlords are learning the hard way because we've gotten away with years and years and years of just winning. Landlords were the superior power for a long time in court. Everything was just a default and the courts just kind of ran the cases through. Now landlords have to prove their case. So no, you can't put in your lease, your tenants don't have a right for you to prove your case. Like, no judge. Actually, that's probably in Missouri, depending on the judge, going to be a usurious term. So I wouldn't try. What you do need in your lease is a waiver of jury trial. Because right now in Jackson County, if your tenant is entitled to a jury trial and requests one, we aren't going to see one until 2025. So you're about to take on a tenant for 2 years or more for free. I would, of course, be filing dispositive motions and advocating in a different direction, but that's the provision you need, waiver of jury trial.
Waiver of jury trial. We'll put that in the chat so we can remember that.
Also, I mean, Missouri upholds waiver of liability provisions. So everything I'm talking about, waiver of jury and waiver of liability, meaning if somebody dies at the property or is injured at the property, you can require the tenant to waive their right to sue you for that in Missouri. Both of them in Missouri, not in Kansas. The nice thing about Kansas is Kansas bifurcates everything. So, you know, somebody could say all sorts of things and we'll still get possession when they don't pay. Like the case earlier we talked about, they're withholding rent because of a screen door. Well, we could easily issue a 3-day notice, go in and get you possession, get these people out of there. And then, you know, maybe later in life, we can deal with the screen door issue.
Okay.
Bifurcation is lovely. We just don't do it in Missouri. So that's why Missouri is so much more expensive and difficult.
So bifurcation basically is one thing doesn't affect the other, so we can deal with one thing and then deal with the other thing later.
Yeah. So in Kansas, we can say we'll deal with possession and then we'll deal with money later.
Okay, so you get it back, but then you might have to give them a little bit because you didn't fix the screen for 3 months or something.
Well, maybe. I mean, that's the thing we love about Kansas. Like we can go in and say they owe rent because they withheld rent. And so we could get possession and get them out and get another good paying tenant who's not going to pull this. And then, you know, 30, 60 days down the road, we might have a hearing on the damages. How much rent do they owe versus how much in the screen door is it going to be deducted? But it doesn't matter because it's not under a lot of pressure of possession. The landlord isn't just losing money along the way. But in Missouri, we have to do everything in one case. We can't just say, hey, landlord, you get possession and then we'll deal with the money later. The best thing you can do in Missouri is just don't wait. Just do not let people get so far behind because the system is broken. The system is so far behind that in Missouri, it's just taking longer than it's ever taken before. Now, Kansas, I mean, you could wait a long time in Kansas and it's going to be really like efficient.
So in Missouri, what did a typical rent and possession, how long did that take before COVID, and what are you seeing it take today?
I mean, there are now 18 lawyers that are paid for by our tax-paying dollars or the legislature, and they know how to manipulate the system. In an ideal world, what used to be 2.5 months is now maybe 3. So you're looking at like a quarter of a year in a perfect world. And in a not perfect world, I mean, you could be looking at a year with no income and a year of bleeding. Bad cases, obviously, we don't want them, but what used to be, again, like 2 months, no income, and you could turn a unit around from an eviction is now 3. You're going to look at a quarter of a year of no income plus the losses that you chose prior to getting to that quarter of a year. And I think a lot of landlords just feel like, well, I'm not a mean person. I'm not a mean guy. I'm not a mean person. So I didn't want to send them over to eviction. So I waited. Okay, well, if you want to wait a quarter of a year to start a quarter of a year process, you now have a tenant who got to live for free for 6 months, and now that's something that they feel very entitled to, or very confident in staying. And there are agencies and there are lawyers that would help them stay
So,
even longer. And we could be looking at a year or two or more. I mean, we're,
so that's where having your policies and procedures and
yes,
enforcing your policies and procedures across the board, one, that trains them that you mean business and you're not just a pushover that they can take advantage of.
don't
And
treat this like a hobby.
And it also gives you or their attorney something to take to court when they do have an attorney. If you have all your policies and procedures and all of your paper trail that you're supposed to have, they can't drag it out for a year and a half because you're doing everything right.
Right. And if they do move in that direction, we have far better tools to file what's called dispositive motions. So we could win on motion practice versus waiting for a trial. But our ability to practice law via motions with lawyer versus lawyer is based on the evidence that the client provides. So do you have a good lease? Do you have good record keeping? You know, the days when you can just, mark something down on a napkin or have a little receipt book, like, it's over. You have to have sophisticated records. I've tried to put minimally sophisticated forms on my website that are self-explanatory. And if you use those, including the ledger, if you don't keep a legitimate ledger in a software kind of format, accounting software, you should be able to get it done. Well, I mean, here's the thing that landlords have to realize is that, our law enforcement is under attack. Like, they are.
Just like we are,
They are
yes.
very, very strained right now for resources. And they do not have time to help people make money in their real estate investment business. They don't have time to clean up your sloppy business practices or your poor decisions to put criminals in your property. I mean, that's kind of the perspective that they're coming in from. Now, I mean, if it's truly somebody's dying, bleeding, crime, drugs, they will come out, but they will not evict them. That is a civil matter. So criminal and civil law are very different. We're completely statutorily different. I'm not a criminal attorney. I'm only a civil attorney. Now, yes, I go to the police academy. Yes, I understand criminal law, but I'm not a criminal lawyer. I'm only a civil lawyer. And the civil courts require you to terminate somebody's right to possess your property, their possessory interests, and for a variety of reasons. If your tenants were criminals and violated the lease, you had to issue in Missouri a 10-day, or in Kansas a 1430. If they didn't pay you, in Kansas a 3-day, and Missouri just a demand. And then we could file a lawsuit based on non-payment. We can file a lawsuit and could have, I don't think I was involved in this case because that's extremely long for a criminal case in Missouri. They're still moving pretty fast on the criminal side if you can prove your case. But again, I need evidence. I don't want to hear, oh, you know what, they're doing drugs. Okay. How do you know? Are you doing drugs with them? No, you're not. Good. Great. We're not doing drugs with our tenants. All right. Did you see them do drugs? Do you know somebody who saw them do drugs? Will they testify? Oh, no, they won't testify. Okay. I don't have any evidence. I have had some really egregious cases that I cannot win. At this point in time, where we are as a nation, it is a big request to ask the police to clean up your business choices. And I know I sound harsh, and there are very many reasons why you need to call 911. But if you made a poor decision in who you leased to, or a decision that you thought was good, and then they brought in poor people, there are remedies, and you need to be actively landlording. That's not a word. I looked it up. But, you know, during COVID, I said, you have to landlord harder than you've ever landlorded. And I was talking about like trying to get rent relief and trying to get government subsidies and trying to get your tenants to pay then. Now that so many people have been living with no consequences for so long, or the government paid for them, we're seeing a lot of bad behavior. I would say I'm seeing a spike. I'm seeing two spikes. I'm seeing a spike in bad behavior. And I think it's because landlords, it depends on the landlord, but they tolerated bad behavior and now they want to be done with it, but they tolerated it before without consequence. So it's just like when you're a landlord and you have tenants, you have to tell them how to act, how to pay, and what the consequence is if they don't. And then you have to follow through on what you said. And if not, you're going to raise bad tenants.
I think it's very similar to what we're seeing. I was watching the news before this, and they were talking about all these fights breaking out on the airplanes. And it's like, well, COVID screwed everybody up and nobody knows how to fly on an airplane anymore. So that's why we're seeing all these issues on the airplane. So they got to retrain the passengers on an airplane how to behave themselves again.
Not to be a jerk. Yeah. I would say legitimate emergency situations are being addressed right now. You know, I have some really violent cases, not a lot, but some, and we're getting them to court. We're getting judgments, and the court is very sensitive to landlords right now that have evidence. You know, when I'm showing up with police officers, when I'm showing up with witnesses, we're winning. Now, if you don't have any of that, yeah, it's going to be really ugly.
So the free attorneys we've been talking about, they're primarily a Kansas City, Missouri, and Jackson County. We're not seeing that necessarily. Well, I would guess Clay County and Platte County also encompass Kansas City, Missouri. So they have the same delays or same issues.
Yeah, I mean, so a lot of these grants are coming in by school district. So the Platte County School District has an attorney. The Kansas City, Missouri School District has a tenant attorney. I'm not sure about Clay, but like somehow legal aid has definitely received a significant amount of money over the last few years. We're seeing contested cases everywhere that we didn't see before. But you know, rather than having the mentality that now we're victims, which I mean, in some ways, yeah, it's going to cost you a lot more. You have to run a legitimate business. And if you don't, there's going to be a consequence for you. Like the world is giving the consequence to the landlord, while the landlord's like, I feel bad, I'm not going to give a consequence to the tenant. And I'm like, okay, well, you either have to learn how to raise the kindergartner or not. The consequence for you is a lot more difficult. You know, we don't just get to win. You don't just get to say to me, they're a criminal, they do drugs. You know, 4 years ago, I could have gone to court and said, they do drugs, we need them out. And the judge would have been like, oh, okay. Not anymore. I have to prove they did drugs. I have to prove the money is owed. And if your records are sloppy and your leases are bad, we're going to lose. And the judges and the lawyers are standing out there high-fiving each other. And it's sometimes it's terribly unjust, because there are some really unfortunate cases, especially on the criminal side, but we can't get witnesses. You know, rape, like the victim doesn't want to show up and testify against the tenant. Well, I'm going to lose. I need evidence now. You have to prove. And that's what's happening also when we're seeing these discrimination cases. I'm now, like, my clients are saying, well, why are you treating me like I'm racist or sexist? I'm not, but we're going to go through a discovery process that's going to show that you might be. And so I need to find out, are you racist on paper? And then we should probably offer something versus have that declared publicly. And it's really hard. And I understand, you know, there's a lot of sad cases. You know, I had a client and he's like, I feel so bad for her. She's a single mom and I was trying to help her and her kids. And then there was a thug that was screaming in his face and he didn't treat them the same. And I feel bad when I have to say to that client, you look racist. And you're going to be found to be racist. So how do we minimize the issue? You just cannot run this business as a small hobby based on your gut anymore. The gut went away before COVID. Like, you have to now run it based on actual legitimate business practices and writing. And don't just tell me that you have them in your mind, because that is not going to work.
Okay, so a couple other questions. One is recommendations for a good property management company that can handle these types of tough decisions. I don't know that you can necessarily recommend somebody necessarily on the call. But I would say coming to the MAREI meetings and asking for people in the room, asking their recommendations. We do have several property managers that come to the meetings that are business members on our website.
Doing a little due diligence though. How long have they been in business? How many doors have they managed? Do they have fair housing training? Do they have processes and procedures themselves? Like, they're going to ask you to indemnify them in their management agreement. And so you want to make sure that they're not going to violate the law and cause you a lot more trouble. I also think a lot of owners have been like, oh, I have a management company, I'm not going to really hold them accountable. No, you need to, because you need to make sure that they're managing and evicting and bringing in quality tenants, screening. You know, you hope not to have an eviction problem. Like,
well, I've found I've dealt with a lot of different property management companies. Back in the early days of MAREI, I had several property management companies that were part of our group, and I got all kinds of calls about how horrible this company was and how horrible that company was, because they had no policies and procedures and at least didn't also get written down on paper. But the property managers that we have that are business members and part of MAREI that we have currently have been there almost, I want to say 10 years or more, and I have not had a single complaint. I can say for one of them personally, they were my landlord for a year and a half, and so I would highly recommend checking out the people on the website and also asking for referrals at the meetings. We had one more question. Can you require minimum credit score for all potential tenants? And I'm going to say, yes, you can, and you should.
oh
You
yeah,
have to apply it the same.
yeah. I mean, if I draft your tenant screening criteria, there's always a minimum credit score. You know, there's always an income. The positive side is, where are you going to put your money to grow? Are you going to put it in the stock market? Are you going to put it in metals and gold and silver and bronze or whatever that is? Are you going to put it in cryptocurrency? We don't know how secure that is. Or are you going to put it in real estate? And historically in this country, real estate has turned a good return. And I don't mean to scare people, and I don't mean to say like it's a bad idea to be in real estate, but you cannot treat it like some sort of passive hobby anymore.
It's a very
Even with
active hobby.
1 or 2 units, you know, I have clients who are getting sued that only have 1 property. And they're like, how could this happen to me? Well, I mean, I don't know. You didn't do it right. You only have to have 1. You can have 1 or 10,000. You are still held in the eyes of the law to the same standard. And so you have to listen when I say you must treat your real estate investment as a business. Or if you want to be a passive investor, you must find a management company that is going to actively manage your business, you know, actively manage your asset as a business. Those are the only 2 choices now. You can continue to try and do business like we did 4 years ago, 8 years ago, 10 years ago. You're going to get sued and it's going to be painful and you're going to be wrong. I am very empathetic for real estate investors all the time, every day, all day. But it kind of stops with, you have to take personal responsibility for your investment. You know, it's not like the stock market. If you really want to passively invest, just throw it into the stock market and see what they do with it. Like, that's an option. But if you don't think that's what you want to do, you want to have more control or a different return, and you want to put it in real estate, it's not passive anymore.
You can't be an accidental or a part-time hobbyist landlord. You actually need to learn your business and make sure you know what you're doing.
Yeah, and if you want to do something more hobby-like, I just really need you to do great screening upfront, get a good person in the property, have solid lease documents, have some processes and procedures in writing, and then follow them. I mean, that wouldn't be that hard on a small scale basis. In my opinion, of course, I'm not in your shoes, I'm only in mine, but I think there's great returns out there. This is a good business. It's not something that I want to scare people away from being like, oh my God, we have to sell everything because it's going to be hard. Yeah, you know what? Returns are hard. Profit is hard. You know, success is not easy. If so, everybody would just do it.
So,
but not everybody can do it.
yeah, I agree. So we are getting, well, we're a little bit past an hour, and I didn't want to go much further on, but I do have a question. If they have specific questions, I mean, I know you're not going to just sit and answer questions for free all day long on the telephone, but if they had a question to see if they had a case that you could help them, what's the best way to reach out to you or your staff?
Email is by far the best way to communicate with me, julie@mokslaw.com. Our website, MO for Missouri, KS for Kansas, LAW for the law.com. I have full-time employees who answer landlord questions all day long. What notice should I do? Should I do this? Should I not do that? We're happy to direct you in the right direction. If there's anything that I could communicate to landlords right now, it's that you need to address the problems right away, fast.
Well, I want to thank you for joining us for happy hour and sharing your knowledge. Well, thank you. Let's everyone give Julie a big round of applause. I don't know how we do that on Zoom, but we want to thank you for helping us out as always. And we look forward to seeing you again at another event. I'm sure we will see you. You seem to be in demand from time to time on getting us all caught up with what's going on.
Happy to do it. I'm happy to talk about. There's just so many times I wish that a landlord would have heard what I had to say before they got themselves into the situation.
Yes, that's why we have these meetings and why we have classes, is so that you can learn what not to do before you do it, rather than after you do it.
I hear the feedback, and I do think investing long-term in rental property is a very smart financial decision. And there's a lot of reasons to do it, and there's a lot of great return potential for all of you. And this is why you're in this group. This is why you're listening to me. And I know I can be a little harsh.
She wants you to learn it. She wants you to go in your
I'm
head.
like,
Yes.
listen.
Yes. All right. Well, thank you very much.
Thanks.
And we will see you next time.
Next time. It's a pleasure.